Good morning, everyone. This is Rebecca Strauss with Miller Johnson. I'm joined today by my colleagues Sandy, Andre. We are here to bring you a pretty short webinar this morning. This is going to be one of those webinars where we are in and out. We will take some of your questions, but the topic of our seminar is pretty direct, and we planned the seminar because of a very common question. Understandably, a common question we were getting last week, and it had to do with the new CDC quarantine rules and what they were and how that interacted with what was happening here in Michigan. So this is very much a Michigan-specific webinar. The first part, we will be reviewing the new CDC guidelines. That, of course, would apply outside of Michigan as well. But the purpose really of this webinar is to talk about the interaction between the new CDC guidelines and the law here in Michigan. I am in charge of advancing slides today, so I'll ask for your grace ahead of time. Today's topics. First, we will discuss the CDC updates so that you know what they are, the people you report to, as well as the employees and supervisors that you help. They are all aware of them, believe me, so you need to be too. We will then review quickly PA Public Act 238, that's Michigan's law for when employees have to quarantine, and then we will wrap it all up with practical advice on how to combine those two topics. So first off, Sandy, do you want to tell everyone about the new CDC guidelines?
You bet. Thanks, Rebecca. Well, good morning, everybody. As Rebecca mentioned, we're just going to briefly review a couple of recent CDC updates, and for the exact reason that Rebecca said, because your employees and your managers are hearing about them in the news, and so you need to know about them as well. The first was issued later last week, talking about the new quarantine time for close contacts. So the CDC has come out and said there are now two additional options in addition to the 14-day quarantine. They reiterate that the 14-day quarantine is best. So again, here we're talking about if you've been identified as a close contact, how long do you need to quarantine? CDC says 14 days is still best, but two additional options. The first is what I'll call a test option. And it's that the CDC says that your quarantine can be 7 days if you receive a negative test, and your negative test or the specimen collected that leads to your negative test is collected at or after day 5, and you have no symptoms during the reported the daily monitoring period during your quarantine period. So all of those things have to be true. You get a negative test, the sample is from day 5 or after, and you have no symptoms during that quarantine period. You can come out of quarantine after you've served 7 days. Now, you do have to continue symptom monitoring and masking through day 14, but in terms of staying away from work or school, the CDC says 7 days. The second new option is what I'll call a no test option. So if you don't get a test or test availability isn't issued, the CDC says you can come out of quarantine after 10 days, again, as long as you have no symptoms during your daily monitoring, so all of those 10 days, and you have to continue symptom monitoring and masking through 14 days. So in both of these new options, you still have to do the continued monitoring and masking up to 14 days, but there are a couple of additional options to get you out of self-quarantine prior to that. But again, I'll reiterate, as they do, the 14-day quarantine is still their best recommendation. So that's CDC update number 1. Let's turn to CDC update number 2. So in the last couple of weeks, the CDC has issued some additional guidance related to close contact evaluation and monitoring. One that has led to some questions that we have been getting is related to what about employees who have tested positive for COVID-19 within a certain period of time, the last 90 days, for example, and they go through their 10-day period and no symptoms and all of those things, and they're back to work. But later on down the line, that individual is identified as a close contact of someone else who's been diagnosed. What do we do with this person? Do they have to reserve a quarantine period, or how does that work? So according to the CDC indicates that if a previously diagnosed COVID-19 positive individual, somebody who'd been diagnosed within the last 90 days, has no current symptoms, they do not need to quarantine. Those with symptoms, again, should begin self-isolation immediately and start that 10-day, 24-hour type of quarantine period, and of course should consult with their medical provider. So from the CDC's viewpoint, folks who've tested positive within the last 90 days do not need to reserve a quarantine period. And NVHHS actually follows this same guidance. This information is in a lot of their publicly available material as well. So if you've been seeing that or hearing about that, that's where all those pieces come from. So that's CDC update number 2. Let's turn to CDC update number 3, and it's actually just a tweak of one of their long-standing procedures that they've had in place, and it relates to those in what they call critical infrastructure types of jobs. And so this update deals with response planning. And so if you remember way back when, there are certain kind of self-isolation and quarantine requirements for what I'll call the rest of us, and then different requirements for healthcare providers and different requirements for those in the critical infrastructure or in jobs that support the critical infrastructure, with the thought that we need to be getting those folks back to work quicker because, of course, they support all of the inner workings of all the things that keep the country running, right? So the CDC, from their standpoint, they have said for a long time that symptomatic critical infrastructure employees who are close contacts have the same quarantine period as all of the rest of us, right? And so their documents actually still say 14 days, which reiterates that their viewpoint that 14 days remains best. But they have for a while now said asymptomatic critical infrastructure employees who are close contacts can do something a little bit different. And the update here is actually that they have narrowed the group of employees that this applies to. So asymptomatic critical infrastructure employees who are close contact are permitted to continue working in select instances with daily monitoring and masking, and we need to be doing that through day 14. But instead of kind of this blanket exception for anyone who falls in this designation, they've narrowed the pool of individuals. It's only when that employee is necessary to preserve the function of the critical infrastructure workplace. So just because you happen to be an employee in that industry doesn't, from the CDC's viewpoint, doesn't mean that you fall into this no quarantine if you're asymptomatic. It really drills down on the individual employee's job and their function as related to supporting the critical infrastructure. So as we mentioned at the outset, we wanted to just review a couple of CDC updates so that because your employees are going to be aware of them, they're going to be asking you about them. But now Rebecca's going to talk to us about how and if those have any impact here in Michigan, given our requirements under PA 238. Rebecca?
Thanks, Sandy. We're going to review real quickly Public Act 238 of 2020. By listening to this webinar and our other webinars, you, our clients, know more about this than apparently our legislature and health officials and others who never talk about Public Act 238. And we feel like, is it really out there? We keep looking and there it is. And in fact, we're going to talk to you about some amendments that the legislature is debating now. But if you feel like you're the crazy one because everyone else keeps talking about CDC rules and is ignoring Public Act 238, we feel your pain. Public Act 238 of 2020, if you remember, replaces the old executive orders that told people when they had to stay home and for how long. It was signed by Governor Whitmer October 28th. It was retroactive back to March 1st, and as of now, has no sunset date, which is very strange. We're hoping maybe that will be changed, but for now, it's law forever. The law says that COVID-19 positive or symptomatic employees must not work for 24 hours plus until their fever has been gone for 24 hours plus 10 days since they became symptomatic or tested positive and their other symptoms have improved. Hopefully you're all familiar with those rules now. For close contact employees, and that's really what's on everyone's mind these days, for close contact employees, those employees must stay home, must not work for 14 days unless the person they had contact with tests negative and the employee is one of these special employees that is excluded from this close quarantine rule. Those employees are almost all healthcare employees and first responders. So if you don't employ those type of employees, those exclusions do not apply to you. There are some amendments winding their way through the legislature. There's two that overlap each other a bit. They've both been reported out of committee now, which means that there might be some support for getting these through, and there might be additional amendments to these amendments as they wind themselves through the legislature. I will not put you back to sleep this morning talking about the legislative process, but suffice it to say, really anything could happen, right? Once you have a bill on this topic, it can be amended on the House floor, and then it goes to the Senate. The Senate can amend it in committee or on the Senate floor, and then if it's passed in a different version, it can be amended again in conference committee. So right now, these amendments add groups of employees that would be excluded from that close contact quarantine period, including critical infrastructure workers as defined by the federal government. So back to the slide where the CDC rules that Sandy talks to you about, where those close contact rules, according to the CDC, do not have to be applied to certain critical infrastructure workers. There is an amendment to the state law here in Michigan that would do pretty much the same thing, but it's not passed yet. Again, we don't know what it will look like in its final form, and we are keeping a close eye on those. These amendments, as they are currently written, do not change the length of the close contact quarantine. They just provide exceptions for certain categories of employees. Okay, so what do we do? Right? If you could just tell us what to do, that would be great. Again, we feel your pain on this and hate to be the bearer of bad news, but this is the situation as it currently stands in Michigan. In Michigan, you should think about this as two separate quarantine requirements. If you have employees that are excluded under Public Act 238, those, again, mostly in the healthcare field and first responders as it stands now, you should follow the CDC rules. But everybody else needs to follow Public Act 238. And again, Public Act 238 does not include these changes to the CDC quarantine rules, right? The PA 238 is static. Its quarantine rules stay the same regardless of what the CDC is doing. Why is this potentially bad news? Oh, well, for all sorts of reasons. Of course, you have a lot more employees out of work, right? These quarantine rules, we know it's making it hard for a lot of you to staff your organizations. For the employees, the impact on them, they're losing income, right? If they're out of paid leave every time they have to quarantine, and the COVID numbers are so high right now across Michigan that people are quarantining more than once, right? They quarantine once and then a month later again, and then a month later again. So it's not hard to run out of paid leave these days. They can apply for unemployment, of course, but it's not fun for these folks. And a lot of them, we know because we get your calls on this, a lot of folks want to come back to work. And a lot of supervisors want you to say it's okay for them to come back to work. And then you are kind of stuck in the middle between PA 238 and what the employee and supervisors want to have happen. So we know that's tough, but that is the state of affairs today, December 7th. We will definitely be watching these amendments to PA 238 very closely. Hopefully there'll be some relief for Michigan employers. Let's answer some questions, Sandy. We got a few in before the webinar started. The first one, are there any updates to required training for employees? I don't think so, Sandy. Have you heard about any updates to required training for employees?
No updates to required training under the MIOSHA emergency rule, but remember that you are required to provide updated training if you change your preparedness plan or any of your own mitigation strategies or safety-related policies, but nothing from the state government on new training requirements.
Perfect. See, there's a piece of good news. I'll be the bad cop and say, a good cop. If we want to be more conservative, Sandy, this is one of the questions. If we want to be more conservative in our organization and require that our employees still adhere to the longer 14 days, what sort of repercussion? I think that from what Sandy and I already said, hopefully the answer is clear and different than what you thought it would be when you asked that question. The rule still is the longer 14-day quarantine period. So the repercussion is actually good. It means you're abiding by the law. There's actually a potential negative repercussion if you don't do the longer 14 days. Sandy, what do you think about that question?
Yep, I agree for all of those same pieces. But even if you were in one of those excluded groups, remember that the CDC, right, their kind of gold standard is still the 14-day period. And so you're not totally out of bounds. And from an employment standpoint, you can set your policies at whatever those pieces are. But as Rebecca said, to the majority of folks who are listening, you don't have employees in one of those excluded close contact groups. And so for all of the rest of us, the rule is still 14 days.
Next question, Sandy, again, is based on the assumption that the CDC guidelines apply and not Public Act 238. So, boy, am I glad we had this webinar, right? Because it looks like from the folks that asked questions ahead of time, assuming they're representative of a lot of businesses in Michigan, the assumption was the CDC guidelines control. So let me ask you question number 3. What about caretakers? If your child tests positive, is it still 24 days of quarantine, or do employees fall under the new CDC Quarantine Guidelines? What do you think about that?
Yep. So again, kind of to be the bearer of bad news here, right? So for us here in Michigan, unless we're one of those excluded groups under PA 238 from a close contact quarantine, this kind of still longer period applies, and it can be 24 days, but it could be much longer, right? And so where that 24 days comes from is that me as a close contact, my 14-day quarantine doesn't start, right? That time clock doesn't start for me until the person I'm caring for is through their infectious period and incubation period, right? So my child has to serve their 10 days, and by that point, they're good to go and can return to school or whatever the situation is. But because I've been caring for them, my last date of close contact with an infectious person starts on the day that they become well, right? That they've been deemed that they can return to their activities. And so, yes, the 24 days, but it certainly could be longer than that, depending on the individual's own symptoms or how ill they are. But yes, we still follow that type of time period unless something changes with PA 238.
Okay, thank you. Another one, again, we're probably just going to be repeating some of what we already said, but because our presentation is actually a little bit shorter, we can answer some more questions. With the new rulings, please be clear on exposure versus having COVID and the difference between the guidelines and the law, and also the difference between symptom date and test date. So that's a whole lot of questions being wrapped up into one. I think in the formal presentation part, Sandy and I discussed the differences in the rules between exposure plus actually testing positive for COVID. We discussed now several times the difference between guidelines and law. See, those are guidelines. Public Act 238 is the law. Sandy, do you want to talk a little bit about the nuance between the symptom date and the test date as to when quarantine begins? And I'm assuming this is not a close contact question, right, but a question regarding someone who actually has COVID. Does the quarantine period begin from the symptom date or the test date?
Right. So, yep, assuming that we're talking about myself, right? If I'm the person having symptoms or I'm the person potentially testing positive for COVID-19, under PA 238, we have that kind of 24-hour, 10-day symptom improving kind of rule. And the 10-day period is really critical. It starts, 10 days have passed from either of the following, whichever is later. The employee's symptoms first appeared, or the date the employee received the test that yielded a positive result. So that section kind of attempts to account for folks who maybe never get tested, as an example, or they have symptom onset and it takes them a while to get tested. You start that 10-day period from whichever of those dates is later. So it accounts for keeping an individual out of the workplace or in quarantine longer. I think that's what the question here is, talking about the nuance between symptom date or test date. And under PA 238, it's the 10 days starts from whichever of those dates is the later date.
Perfect. Thank you. Now, we had a number of questions come in during the presentation as well, which is not surprising. I'll take a few, and then Sandy, if you want to jump in and take a few too.
You bet.
Let's see. What is the definition of critical infrastructure for the exclusion? So that would apply to the exclusion under CDC Guidelines, which again doesn't yet apply in Michigan. But I also mentioned that exclusion when I was talking about potential amendments to PA 238 that would adopt that exclusion. There is a federal document by one of the acronyms for one of the federal agencies, CISA. I never know how to pronounce it, so I won't try. The person that asked this question is anonymous. If you send me an email, my email's up on the screen right now. If you send me an email, I will send you a copy or a link to that document. There is a federal document that goes through what the federal government considers to be critical infrastructure. And that is what is incorporated by reference into the CDC guidelines and then possibly into PA 238 if those amendments go through. Let's see, here's another one by anonymous. What if we decided to follow the CDC requirements instead of Public Act 238? What is our risk? That is a fantastic question. I'm going to answer it, sort of, but I'm also going to say this is a situation where you may need one-on-one counseling, right? Because it depends on a lot of things, on the nature of your business, on the specifics of your situation. So this may require individual counseling, and in fact it should. But the risk of violating Public Act 238, Public Act 238 provides for a private cause of action. That means that if you violate it, an employee can sue you, okay? For the violation, they can sue you for the damages they suffer for you not following Public Act 238. The other potential downsides are there's this new immunity statute in Michigan that provides immunity from torts, from lawsuits, people suing you because they were exposed to COVID-19, but you have immunity if you're compliant with all the various COVID-19 laws and regulations. So if you did not follow 238, you would not be compliant, you would not be entitled to that immunity. It's a little unclear to me, Sandy, how MIOSHA would look at this if they came in, because MIOSHA is less concerned with Public Act 238, and they seem more sensitive to the CDC. Sandy, you've been involved in a number of MIOSHA investigations related to COVID-19. Do you have a sense of how MIOSHA is looking at compliance with Public Act 238?
I don't, except to say I'm not sure that they are at all, because as we know, right, the MIOSHA emergency rule talks specifically about when we let an employee with a known or suspected case of COVID return, and that's specifically linked to the latest guidelines from the CDC and being released from a quarantine or isolation order. And MIOSHA has a couple of FAQs up on their web page that talk generally about some additional CDC guidelines. And so that's kind of a trigger to me that they're not thinking about PA 238, kind of as Rebecca mentioned in her portion of the presentation. We've got a myriad of government officials here in Michigan who aren't talking about PA 238, which is part of the issue that's causing the confusion. So the shorter answer is I don't know. You wouldn't get dinged for a MIOSHA citation, certainly, if you're not following PA 238. That would be outside of their scope of enforcement. For sure.
Perfect. Okay, I'll take one more, Sandy, and then I'll stop hogging all the airtime and let you take it. Let's see. Sarah just asked a really good question. We are considered an essential business because we provide products and services to customers who are first responders, healthcare workers, etc. Can we argue that we are allowed to follow the CDC recommendations? Under a strict reading of PA 238, the answer to that sadly is no. But this is one of those situations where you may want to talk to one of us one-on-one to discuss the various risk factors and what makes sense for your organization. Okay, Sandy, what questions came in that you can answer?
You bet. I'll answer a couple of pay-related questions. We've got a question here related to FFCRA. What if an employee has exhausted all of the FFCRA paid leave entitlements but continue to be off for COVID purposes? Will the FFCRA start over in the new year, or is it a lifetime maximum? Well, that is, if we're making a list of million-dollar questions, that certainly hits the top 10. As of right now, the FFCRA is set to expire on December 31st. So if your employee has exhausted their 80 hours by that time, starting on January 1st, if they're off for a close contact reason or their own symptoms, there isn't a federal paid leave provision that would apply to them. But as we know, that is an evolving situation, and we have a federal government administration change coming in the beginning of the year too. So a lot to watch for developments there. The second question is also a little bit related to pay. What is the situation with unemployment in Michigan in terms of extension after the pandemic assistance runs out at the end of the year? So a couple of pieces here. One, remember the federal addition to Michigan unemployment, that exhausted at the end of July. So that has not been in play for a while. But a couple of months ago, I think in October, the Michigan legislature formally codified what used to exist as Executive Order 76 and made an amendment to the Michigan unemployment statute, which essentially added a number of COVID-related reasons as being reasons that an individual would not be deemed ineligible for benefits. And one of those is if you are and I'm paraphrasing here, but essentially if you are a close contact and you're serving a 14-day quarantine period, right? So if you're not receiving pay under FFCRA or your employer is not paying you, that is a reason that you would not be disqualified for benefits, and you can apply for benefits and receive them. But right now we're back to the weekly maximum of $362, which is the Michigan maximum, and the federal dollars don't come into play here. The federal edition under CARES expired at the end of July. There was additional money from the federal government through FEMA, but that ran out in the beginning of September. So we've been back to just Michigan dollars for a while now, and that's what remains on the table here. I saw one more question that I can answer, specifically related to certain types of jobs. Would you consider this type of job to be an exclusion under PA 238? And so I can answer it a little bit here. So under PA 238, remember, we talked about there's specific jobs that are excluded from the close contact quarantine period, and those are a healthcare professional, a worker in a healthcare facility, a first responder, a child protective service employee, a worker at a child caring institution, a worker at an adult foster care facility, and a worker at a correctional facility. Some of those terms are specifically defined, meaning, as this term is defined under MCL, so on and so forth, but others are not. So as related to this specific question, are jail corrections officers falling into that excluded group? Yep, corrections officers are specifically named there. Related to the other types of jobs that you mentioned in that question, this is from Anonymous, that I don't know. We would have to look and see if those types of jobs fall under any of these other types of definitions that are defined by a different Michigan law. But long story short on that is PA 238 does spell out the specific exemptions, and so to determine if you employ anyone who might fall into those exemptions, you just want to pull up the Public Act, and we can throw that in the chat here maybe too.
Perfect. Thank you, Sandy. Let me just address these last two, and then you can chime in too, for sure, Sandy, if you'd like, but I think these are, they both, actually there's three, that have to do with MDHHS. The MDHHS, as we know, updated its guidance last week. I think it was Friday, although days started blurring together, to adopt the new CDC quarantine guidance that Sandy reviewed earlier in this presentation. So because MDHHS updated its guidance, many folks understandably thought that was, or think that is, the new quarantine guidance. But then they just heard from us, Sandy, that wait a second, what about Public Act 238? That has not changed along with CDC guidance. So what do? Unfortunately, as it stands right now, Public Act 238 is the law. MDHHS has a more lenient quarantine guidance that's similar to the CDC's, but employers are still required to follow the more stringent Public Act 238. It is extraordinarily frustrating for the business community and for us advising the business community that there seems to be a bit of a disconnect, right, between these two things, and between Public Act 238 and between the Health and Human Services guidance. We are hoping that situation will change. And if it does, we will let you know immediately. But as of right now, that's where things stand. And then the last question, have we heard of a governor's press conference today regarding new guidance? I have not heard of a press conference, but I know one is coming up in the next day or two. I just haven't seen it scheduled yet. But Sandy seems to know when these things are scheduled before they're actually scheduled. So Sandy, what is your latest on that?
My sources have not told me that one is scheduled today, but as Rebecca said, we anticipate one, if for no other reason than the MDHHS, the existing MDHHS order expires tomorrow at midnight. So we know that something is going to happen, and maybe it will be nothing, maybe it will be an extension, maybe it will be, who knows what it will be. But we know something will be happening in the next day or so, and you could trust that we're monitoring all of that very closely.
Perfect. Okay, with that, we will let you all go, get back to your Mondays and your weeks. We hope it's a good week for everyone. And as always, as the situation changes, we will keep you updated. Thanks and have a great day.
Thanks, everybody. Bye-bye.